Honorable Justice Campus Somasekhar, Chief Justice of High Court of Manipur. And also, I would like to request Honorable N. Kritisan Singh to present the bouquet to our honorable guest of today's guest of honor, Honorable Justice Ahantem Bimol Singh, High Court, Chief Justice, High Court of Manipur. Next, I would like to request Judicial Magistrate Senior Division, Chief Judicial Magistrate cum Secretary DLSA Bishnupur, Srimati Bineshwori Maibam, to present our lengyan and bouquet to our esteemed guest, distinguished guest, Shri Ozes Mutum, Registrar General of High Court of Manipur.
Sakshya Adhiniyam BSA 2023. For over a century, our criminal laws were governed by colonial era laws like the IPC, CRPC, the Indian Evidence Act framework. The foundation was there. We feel like that it was no longer fully addressing the complexities of a modern digital India. With rapid advancement in technology, and changing crime patterns and the growing relevance of electronic and digital evidence, there was a pressing need to reform and modernize the legal structure. This new laws aims to make justice delivery more efficient, victim-centric, and technologically advanced, adaptive. And it is ushering in a future-ready legal framework. Today's discussion will shed light on key aspects such as arrest and detention, procedures, handling of serious offenses, and the challenges and opportunity posed by digital and electronic evidentiary system. To mark the auspicious beginning of this important program, we shall now proceed with the lighting of our ceremonial lamp, a symbol of knowledge and enlightenment. So I would request our esteemed dignitaries to come forward for the candle lighting ceremony. I also request Sir and Kritishan to join the candle lighting ceremony. And also Sri Ravi Kumar Khetrimayum, Superintendent of Police IPS, Bishnupur. With the lighting of the ceremonial lamp, we have officially started our today's program. We would now like to felicitate all our panel members of today's discussion. So we would present a humble lengyan to all of the panelists. So I request all our volunteers. Let me remind you, we are still awaiting for Justice A. Guneshwar Sharma and Dr. Yumnam Premananda Singh. We will proceed with the felicitation of, first of all, Sri Ravi Kumar Khetrimayum, IPS Superintendent of Police, Bishnupur. He is one of our esteemed guests of today's program. We would like to felicitate. We will continue with the felicitation of our panel member. I request our Yelambam Ramananda, Sir Ramananda, Chief Legal at Defense Council, Bishnupur. It would be better if... Oh. Shilapur. Madam Eliza Maisnam would felicitate with President Lengyan to Sir Ramananda. Thank you, sir. Next, I would like to request Sri Yumnam Premjit, MPS, Additional SP, Bishnupur. Sir would be felicitated by Madam Binita. Next, I would like to request Sri Thoksom Hemchandramitai, Secretary, Bishnupur Bar. He is one of our panelists today. He would be felicitated by our Madam Binita. We would also like to felicitate media person Thoksom Jogendra, IIS, Assistant Director News, Akashvani Imphal. I guess he's still on the way. Next. Last but not the least, we would like to felicitate the moderator of today's panel discussion, Sri T.H. Sudhir, Deputy Legal Aid Defense Counsel, Bishnupur. Sir would be felicitated by Madam Principal Eliza. I would like to address that our esteemed guest of honor of today's program, Honorable Justice A. Guneshwar Sharma, Justice High Court of Manipur, has also arrived for today's program. We would like to present a small, humble bouquet and lengyan to him as mark of respect. We would like to request Madam Principal Eliza Maisnam to present the bouquet and lengyan to our respected Honorable Justice A. Guneshwar Sharma. Once again, we extend our heartfelt warm welcome to all the distinguished dignitaries who have graciously agreed to join for today's special program on this auspicious day of July 12, 2025. We continue with our felicitation program. We would like to felicitate our resource person of today's panel discussion, of our today's technical session, Nira Sinam, Judicial Magistrate, First Class, Kakching. She would be delivering a topic on procedural irregularities in arrest or detention and its impact on remand and trial. So we will await for the presentation later on, but first of all, we would like to felicitate Madam. Madam would be felicitated by our principal, Eliza Maisnam. We would like to request our volunteer to present a lengyan. Resource person of today's program technical session, Nira Sinam, Judicial Magistrate, First Class, Kakching. The next resource person of today's technical session, Rajashree Yambem, Judicial Magistrate, First Class, Bishnupur. We would like to felicitate her. She will be felicitated. She will present a humble lengyan by our Madam Coordinator, Binita Kumbongoyum. As we wrap up the presentation of lengyan and bouquet to our distinguished guests, we will now proceed to the next phase of today's program. We would proceed with the welcome address of today's program. I would like to request Srimati Eliza Maisnam, Principal, Royal Academy of Law, Oinam, to present the welcome address.
Honorable Chief Guest, Honorable Guest of Honors, distinguished dignitaries, respected speakers and panelists, esteemed faculty members, dear students and participants, a very good morning to each one of you. It is my great honor and privilege to extend a warm and heartfelt welcome to all of you to this one-day legal awareness program on the theme Arrest and Detention under Criminal Laws, BNSS, BSA 2023, and its impact on serious offenses and electronic evidentiary issues. This important program is jointly organized by District Legal Services Authority Bishnupur in association with the District and Session Court Bishnupur and the dedicated mediation center Royal Academy of Law Oinam. We are gathered here today to explore an extremely relevant topic, especially in light of the newly enacted criminal laws. These reforms aim to bring our legal system in line with contemporary challenges, ensuring fairness, transparency, and a citizen-centric approach to justice. On behalf of the Royal Academy of Law Oinam, I take immense pride in welcoming the dignitaries gracing today's occasion. Honorable Justice Kempia Somashekhar, Chief Justice, High Court of Manipur, our most respected Chief Guest. Honorable Justice Ahanthem Bimol Singh, Judge High Court of Manipur, our distinguished guest of honor. Honorable Justice A. Guneshwar Sharma, Judge High Court of Manipur, our esteemed guest of honor. Dr. Yumnam Premananda Singh, Head and Associate Professor, Department of Law, Manipur University, Canchipur, our respected academic speaker. He is on the way, still not arrived. The respected Registrar General, High Court of Manipur, Mr. Ojas Mutum. My warm welcome to Srimati Bineshwori Maibam, CJSD, CJM, cumSecretary, District Legal Services Authority, who will deliver the keynote address. I would also like to extend a special and respectful welcome to the Honorable District and Session Judge Bishnupur, Sri Nongthongbam Kritichan, whose tireless dedication, day and night, has greatly contributed to the success of this program. I would like to extend my warm welcome to our founder principal, Sri I. Jugeshwar Singh, and to our dear alumni, whose continued connection and contribution make us proud and strengthen the legacy of the Royal Academy of Law. T.S. Johnson Singh, District Legal Services Authority Bishnupur, your gracious presence today truly enrich this important initiative, and we are deeply honored to have you all with us. We are also privileged to welcome Nira Sinam, Judicial Magistrate First Class Kakching, Rajashri Yambem, Judicial Magistrate First Class Bishnupur, Sri Ravi Kumar Khetrimium IPS, Superintendent of Police, Bishnupur, and other police personnel who play a crucial role in upholding law and order in our society. Now, turning to our imminent panel discussion later today, I am honored to welcome the distinguished panelist, Sri Yelam Ramananda, Chief Legal Aid Defense Counsel Bishnupur, Sri Yumnam Premjit, Additional SP Bishnupur, Sri Thokchom Hemchandra Mitai, Secretary Bishnupur Bar, Sri Thokchom Jogendrajit, IIS Assistant Director, News Akashvani Imphal, Dr. Yumnam Premanda Singh, Head and Associate Professor, Department of Law, Manipur University. I also extend a special welcome to T.H. Sudhir, Deputy Legal Aid Defense Counsel, Bishnupur, who will moderate the panel discussion. We warmly welcome all members of the media and electronic press. Your presence and coverage play a vital role in spreading awareness and ensuring the success of today's program. We are grateful to all the guests, students, faculty members, legal professionals, and dignitaries, and all the invitees who have taken time out of their busy schedule to join us today. Today's topic, arrest and detention under the new criminal laws is not only legally significant, but socially vital. These updated frameworks under the BNSS and BSA 2023 are designed to strengthen due process, clarify the rights of the accused, and ensure the use of modern evidentiary tools such as electronic evidence, all while safeguarding the rule of law. We hope that today's program will ignite insightful conversation, enhance legal understanding, and inspire positive action both in the courtroom and the classroom. With this, I once again welcome all of you and wish today's program great success. Thank you.
Thank you, Madam Principal. Our esteemed guest of today's program, Sri Dr. Yumnam Premananda Singh, Head and Associate Professor, Department of Law, Manipur University, has arrived and have taken his seat on the dais. So we would like to felicitate him with the Lengyan. The Lengyan would be presented by Madam Principal Eliza Maisnam. Thank you, Madam. After the felicitation, we'll now proceed to the next phase of the program. We have a keynote address, but before that, we would like to mention Madam Srimati Bineshwori Maibam, CJSD, CGM, cumSecretary, DLSA Bishnupur. I would like to remind everyone that she is an alumnus of this college, and she has returned this college as CJSD and CGM, and it is with great pride that we welcome her on today's program. I would now request Madam Srimati Bineshwori Maibam, our alumnus, and CJSD, CGM, cumSecretary DLSA, to present the keynote.
First of all, thank you for such a lovely introduction. Honorable Mr. Justice Kempaya Somasekar, Chief Justice of High Court of Manipur and Patron-in-Chief of Manipur State Legal Services Authority. Honorable Mr. Justice A. Bimol Singh, Judge High Court of Manipur and Executive Chairman of Manipur State Legal Services Authority. Honorable Mr. Justice A. Guneshwar Sharma, Judge High Court of Manipur and Chairman of High Court Legal Services Committee. Respected Sir Ojesh Mutum, Registrar General of High Court of Manipur. Senior Advocates, Sir Nongthombam Kirtichan Singh, District and Session Judge, Bishnupur. Dr. Y. Premananda Singh, Head and Associate Professor, Department of Law, Manipur University. Shri Ravi Kumar Khetrimium, Superintendent of Police, Bishnupur. My fellow judicial officers, learned advocates, officers from the Police Department, District Administration, esteemed professors and faculty members from the Royal Academy of Law, police officers, public prosecutors, investigating officers, and representatives of press and media. And most importantly, our bright and aspiring law students. Ladies and gentlemen, a very good morning to all. It is both an honor and a privilege to be a part of this significant legal awareness program on the new criminal law, Bharatiya Nyaya Sanhita BNS, Bharatiya Sakshya Adhinyayam BSA, and Bharatiya Nagarik Suraksha Sanhita BNSS. These laws represent a bold and much needed reform in our criminal justice system, aimed at making it more citizen-centric, technology-driven, and transparent. I would also like to mention here that, as conveyed by Sir Nongthombam Kirtichan Singh, that this program was requested from the police department so that such awareness program could give a much better understanding to them. This program is not just a platform for dialogue, it is a convergence of experience and aspiration. For our judicial officers, advocates, investigating officers, prosecutors, it provides a shared space to deepen our understanding of the nuances and responsibilities under the new framework. As for our law students, this is an invaluable opportunity to engage directly with the pillars of the justice delivery system and witness how the law functions beyond the pages of textbook. In particular, the discussion today on arrest and detention and the use of electronic evidence are highly relevant. These are not only central to the criminal jurisprudence, but also in areas where the law has undergone transformative changes. For instance, under Section 35 of the BNSS, arrest without warrant is permitted only when absolutely necessary to prevent further offense, to ensure proper investigation, and to avoid tampering with evidence. Crucially, the police must record reasons for making or not making the arrest, especially in cases which was punishable with imprisonment up to 7 years. So this shift ensures that arrests are not mechanical, but reasoned and accountable. The arrested person must be informed on the ground of arrest, their right to bail, and given the opportunity to inform their relative or a friend. Section 187 of BNSS further outlines clear timeline for the police and judicial custody, after which the police becomes eligible for default bail. The law now places equal emphasis on protecting the rights of the accused, and as it does on enabling effective investigation. What is commendable is the integration of technology under the new criminal law, mandating videography of searches, digital records of the arrest, and stronger protections of women, children, and senior citizens. These changes are not merely procedural, they are deeply constitutional, ensuring that liberty is not sacrificed at the altar of expediency. These reforms have made one thing clear: justice must not only be done, but must be seen to be done, fairly, transparently, and efficiently. It is therefore imperative that we organize this awareness program across the state, not only in the capital city, but in every district, so that knowledge about the law reaches to every stakeholder, every practitioner, and most importantly, to every citizen. I would like to thank the Manipur State Legal Services Authority and Royal Academy of Law for taking the initiative to organize this important awareness program, especially for the police. It is through such collaborative initiatives that we can ensure that effective implementation of the new law and to create a well-informed legal ecosystem. With this, I would like to end my keynote address. I wish everyone that this program is a successful one. Thank you.
Thank you, Madam Srimati Bineshwori Maibam, Civil Justice Senior Division, Chief Judicial Magistrate, cumSecretary, DLSA Bishnupur, our alumnus of this college. I hope she would definitely inspire our aspiring budding lawyers to occupy important positions in the future. Next, we'd like to request, we'll proceed with the next phase of the program. We have a speech by our esteemed guest, Sri Dr. Yumnam Premananda. He is the head and associate professor, Department of Law, Manipur University, Canchipur, and he would be presenting a speech on the topic, Way Forward since the enactment of Criminal Laws 2023. May I request Dr. Yumnam Premananda to speak on the topic. Thank you, sir.
My allotted time is 10 minutes as per this invitation. And I hope this program is very important in one sense that come to my mind when I was sitting over there. In this platform, now the meeting of three pillars of effective administration of criminal justice, particularly justices of the High Court are here. Then the person who are directly dealing with the law teachers are here. Then advocates are here. Then student of law, they are the futures of, they may become advocates or teachers or judges. So this is a very important in one sense. These are three pillars of effective administration of justice are here. And above all, policemen also here. We are discussing about arrest, detention, all are relating with police. So everyone is here. So first of all, it is a very my privilege in this one-day awareness program inaugural function. We have Honorable Justice K. Somashekhar, the Chief Justice of our High Court, means Manipur High Court. Then another Justice, we also respect much, Anthem Bimon Singh. Then another High Court Justice, A. Guneshwar Sharma. I think all High Court sessions are now shifted here. Everyone is here. So let me sum up and the principle of this law college, then advocates and other dignitaries. So in 7 minutes, let me sum up way forward after this enforcement of three criminal laws. Actually, this criminal laws is in the concurrent list. So because of that, I think there are a lot of state amendment will come later on. See our all CRPC, IPC, this and that, these are all criminal law, so state amendment will come up, okay. So that is my first submission. That is under the third list of the 7th schedule of Indian Constitution. There's a concurrent list. The next is, all this new criminal law is a very, sometimes we are not familiar with this word of this criminal law, but now we are familiar. So that's the things. So this is not only this not newly comes out. This all relating with the judgment and the committees of our great judges. And my first credit give to the Justice J.S. Brahma Committee Report 2013. I have that committee report with me. That will be highlighted in the panel discussion, in technical last part. So Justice J.S. Brahma Committee Report 2013 is very, very important. All these changes comes in the Indian criminal law, particularly this IPC, CRPC evidence because of this Justice Jagadish Sharan Brahma Committee Report. And here, let me remind you one thing. In India, sometimes we need to sacrifice for the law reform. So Nirbhaya, Delhi gang rape case, okay. December 16, 2012. Because of that, Justice J.S. Brahma Committee was constituted by the ministry. Okay. So this is India. Sometimes happen. Law reform is not coming by this in that way. Because of this, gang rape, then public protest, then ultimately we come to the law reform, particularly criminal law. So that is the thing. And one professor, when I attended one seminar in the New Delhi, they give a joke. What is the government is doing? So criminal reform, we need gang rape, protest. This is the thing. So this is something happened because of the way saying India is great. So this is one thing. All those changes in criminal law comes up because of Justice J.S. Brahma Committee report. Then let me highlight some cases. This is directly related with these changes and the way forward also. So we need way forward means here the act. One of the very important things of Indian judicial system is judiciary is very active. We told our students that we call this judicial activism, this and that, but because of judiciary we are here. So in case of this death penalty, this and that, Basan Singh, state of Punjab, then I am not going further, Maruram, then Masi Singh case, something. And in a new law, you may find sexual harassment, okay, sexual harassment in the 2013 amendment. Then now sexual harassment is occupying very important place in under criminal law in India. This is because of nothing, Bisakha case, 1997, Bisakha against state of Rajasthan case, clear by 3 judges, 2 division bench. Then now in the criminal law, you may find one more thing, the company's fine. Before that fine goes to the government. Now fine should be fair, reasonable fine, and it should be given to the victim. Okay, and it should be covered all the medical expenses to the victim. Mostly this jurisprudence also emerged from the decision of the judiciary, particularly Supreme Court India. Mostly they started from Chairman Railway Board against Sanjay Madas 2000. Then child is nowhere defined. Now it's started defining in the Indian law, below 18 years, okay, in the uniform. This is also because of the one judgment of Supreme Court, there's independent thought against Union India 2017. Means all the changes in our law is because of decision of the judgment of the Supreme Court and High Court. Then we are talking about arrest, detention, this and that, right of arrested person, all are highlighted because of the new changes comes of the right of arrested person. The changes in the Indian CRPCs come because of D.K. Vasu against State of West Bengal 1996, that also division bench, 2 judges decision. So what my simple summation is that all changes, India most active organ of the government is the judiciary. Sometimes executive sleep, sometimes legislature, something. Okay, but judiciary is very active because of that we are surviving here. Then 3 criminal laws. Bharatiya Nyay Sanhita 2023, Act 45 of 2023, Bharatiya Nagarik Suraksha Sanhita 2023, Bharatiya Saksya Adhiniyam. These are the 3 acts. And some are new, some provisions are new, some provisions are already exist in our criminal justice system. Bharatiya Nyay Sanhita 2023, mostly teacher, we are giving more emphasis on the executive law. And the procedure law, I think I have no much knowledge on the procedure matter, CRPC. I think our advocate and police are well known about that. So if you want to know why this 3 Sanhita was enacted, please read statement of object and reasons of the passing of that bill. Okay, I'm not reading. Just I am mentioning you, students mostly, they never read statement of object and reasons why Parliament introduced that bill and passed into act, because it should be highlighted in the statement of object and reasons. So always the students should start reading from there, then you may get what are the changes because of this act. Just my part, just I am confined to some part, that is in this new law, particularly Bharatiya Nyay Sanhita, there's a new punishment is incorporated, is called community service. So I sometimes don't think otherwise, okay. No need to appoint sweeper in the Royal Academy law now. Just to drunken person, okay, they are behaving in the public places. And magistrate, please award community service to sweep in the Royal Academy law. Okay, that provision is there. This community service is now new form of punishment under Bharatiya Nyay Sanhita. That is the new things comes up. Then another is mob violence and the mob lynching is included in the Indian law. Before the state has their own laws. Manipur also, we formed one bill, then that was sent to the president, and no assent, nothing from the president. Okay, and now it's a very, this idea is very good. Now we have mob violence or mob lynching. In Manipur, there was a lot of incident of mob violence, mob lynching here. Every day we are experienced. So in one meeting, I already said, if there's no law, okay, fine, you may escape from law. But now law is coming. If you want to do, then better you do before the enactment of Bharatiya Nyaya Sanhita. Okay, but now Bharatiya Nyaya Sanhita is coming. So no more violence, no more mob lynching. You will punish under this sections 57, then section 70, section 103, 117. So mob lynching, mob violence. Doing justice on the roadside is one of the practice in Manipur. So now no more justice on roadside, no more violence. Okay, this is prohibited, and you may be punished and prosecuted under the law. This is a new we are hoping in Manipur there will be no more violence, no street fighting. Okay, we are hoping there will be Manipur under the rule of law. Rule of law means we are talking about these three criminal law. We are hoping so. Another is imprisonment for life. Okay, we are thinking imprisonment for life, but now new changes, not new changes already there because of Supreme Court ruling. Imprisonment for life, which shall mean imprisonment for remainder of that person's natural life. This is a new thing comes up. I am reminding you, imprisonment means two, just imprisonment for life. Another is imprisonment for remainder of that person's natural life in prison. Okay, actually this is not new things that I already highlighted. There's one famous case is there that is emerged from this case. So I salute our Supreme Court and our High Court. Okay, that case is Swami Sardananda, Eliza Murali Manohar Mishra against State of Karnataka, 2008 case, 2008 Supreme Court, 3 judges. Okay, so what I am saying is that our judiciary is very active, our judiciary is very strong. I always said our judiciary is more powerful than judiciary of American Supreme Court. Why? Because of Article 142 of Indian Constitution. Our Supreme Court can pass any order to do complete justice. That provision nowhere found in any constitution of the world. So that is thing. This new things comes up. Imprisonment for life. That also imprisonment for remainder of that person national life. Section 64, 65, 66, 104, 109, 139, 143, etc. The another is offenses against women and child is separate chapters. Before that we have to search where is the offense, rape is where, then assault is where. We have to search open it, every page of the IPC. Now new chapter incorporated that is known as the offenses against women and child, chapter number 5, from section number 63 to 99. So separate chapter for the crimes against women and child. So that is a very innovative idea, very important things for this Indian Penal Code, Bharatiya Nyaya Sanhita. Okay, I'm not coming on that angle. Then reasonable, just and reasonable file to meet medical expenses and rehabilitation of victims, so on and so on. Then provided that such fines shall be just and reasonable to meet the medical expenses and rehabilitation of the victim. That was not specially provided. Okay, that also because of Supreme Court ruling. Now this is inserted here. Fine means just and reasonable fine. That also for the medical expenses of victim, and that should be also one provision was there. It should be also given to the victim. That is clearly says by the law. This is under section 65, section 70, and section 124. Then another thing, very interesting thing, also introduced a new law that is a rash and negligent driving. Actually, this started from the ITs, Premananda Katara case. Okay, to road accident in India, the road accident, people are dying, we are watching and we are making videos. We are not saving their life. This is happening. Okay, so now they are saying that any road accident, rash and negligent driving, then if something happened, then you have to report to police, the driver. The person who is driving the car, driving the vehicle should report to police. If not, punishable. That is the first time introduced. Another is organized crime. In Manipur also we are facing organized crime, drugs, human trafficking. These all are weapons related things. All are organized crime. There's no law. Law are there. In Mumbai, this is Mokosa, this and that, and UP law is there, but we have not law. But now we have all India law. Organized crime is punishable as an offense under section 111. 111, very easy to remember. That is the new thing, very good. I think in Manipur there will be no organized crime because of this. But still we are having. Then Terrorist Act is introduced in this act. Before that terrorist activities are handled by Unlawful Activity Prevention Act 1969. Okay, but now we introduced under the General Law of the Land. That was a special law. Now General Law of the Land is introduced Terrorist Act under section 113. That's a very important thing. Any act that strike terror in the mind of people, they are terrorist act, they are punishable. So it means without declaring terrorist organization, the act itself is punishable under Indian Penal Code. That's a very interesting thing. Then act endangering sovereignty, unity, integrity of India, section 152. New avatar of 124A, sedition. They say sedition will be abolished, but sedition is modified and enlarged. That's a different thing. I'm not going to comment on that matter. Then suicide is not there, but attempt to commit suicide, but to compel or restrain exercise of lawful power, 226. The snatching, this and that. So what my submission is that these three organs of government, state, executive, judiciary, and the legislature should go together. One organ is active, another is not doing. I think our administration justice system will not do properly. Okay, so my humble submission, but we are very grateful. We are very proud of our judiciary, particularly Supreme Court and High Court. Okay, so still we hope Supreme Court, High Court, wherever. High Court is a special power. Under Article 226 and Article 227. Article 227, superintendent over all court within its jurisdiction. So please exercise this jurisdiction, 227. And whoever, any subordinate court, something, any person doing something, please give superintendent over it. So I hope our Supreme Court, High Court will deliver not justice in the courtroom, justice for the all needed person. Okay, thank you for my invitation.
Thank you, Dr. Yumnam Premananda Singh. Sir is an integral part of this college. He is a prolific speaker, and it's always an immense pleasure for us to speak and listen to him every time. We would like to proceed to the next program, which is a speech by the guest of honor. But before that, we have many aspiring lawyers, and I prepared a small biodata for all of our judges. I would like to read out. If any mistake is there, I would seek for pardon. But this is just to inspire the illustrious career of all our judges present over here. So first of all, I would like to read out a brief legal journey of Sri Honorable Justice Arivam Guneswar Sharma. Justice was born on the 1st of March 1967 in Yai School. He graduated from DM College. He obtained MSc and LLB from Delhi University. He started his legal practice and enrolled in the Bar Council of Delhi in 1966. He then became an advocate under court at the Supreme Court of India in the year 2003. Practiced in New Delhi for over 15 years, 15 glorious years, appearing before the Supreme Court and Delhi High Court, CAT and consumer fora. He has served as standing counsel and legal advisor for major corporations and public sector bodies. He had also an illustrious judicial career. He joined the Manipur Judicial Services directly as a Grade 1 officer in the year 2010. He served in multiple significant positions, including a district and session judge, Imphal East, Tawal, Imphal West, Registrar General of the High Court of Manipur, 2016 until 2021, Member Secretary, Masalsa, Presiding Officer, Revenue, and Cooperative Tribunals. Judicial appointment, he took oath as Judge of High Court of Manipur on 6th of February 2023, and prior to his elevation, he was the senior most district judge in the state and the only officer holding the super time scale rank in Manipur's district judiciary history. And he has also done many public outreach and contributions. He has institutional contributions like framing rules of the High Court, conducting large-scale judicial recruitments, establishing family courts and fast-track courts. As Legal Services Authority leaders, he has pioneered in live legal phone-in programs on All India Radio and Doordarshan, legal talk shows on local FM radios, and community outreach program. It is my honor to say that Honorable Justice Aribam Guneshwar Sharma stands as a shining example of service, scholarship, and dedication within our judiciary. I'm truly honored to request him as he joins today's program. I would like to, may I request him to join the podium and deliver the speech of guest of honor, Sir Justice Aribam Guneshwar Sharma.
Good morning to everybody. Honorable Chief Justice, Justice Case Homicide, Honorable Justice A.B. Moore, Registrar General Mr. Ojas Putum, Oja Premananda, Head of Department Law, Manipur University, Mr. Kritisan, District Judge, Judicial Officers, SP, Oja Jugesor, other teaching and non-teaching members of the Oinam Law College, a police officer, distinguished guests, and learned members of the bar. Since the audience is multiple, I took the permission of Honorable Chief Justice to do in bilingual. The theme of today is three-part. One is the essence of legal service, two is the new three criminal law, and third is the electronic evidence, is the new emerging law. Akoi sida imaiben sing bayam yawiri IDP su yawiri. Akoi legal service na ma hek tadi tai adu karino munda khambi do sai na haijana. Akoi India ki constitution da article 39 capital E habam yawe. Kai hagi da India da leiba mi khudibak se India ki leiba law na piba amasum scheme na piba amasum law na piba protection se sab madana phangalo na hai si kariyumba bi mana paisa pai daba lari ga hitaba natraga ai laibham labna leiba sing mandra yibidagi si khudong cha se law phangdragadi sarkarna scheme guba ekumba sebo hai ba si bi khudimakta logi sakthung se manana pina ba aduna koi law da theory da manani hai su practical da di bi khudimak se sakthung se manana phangde khara power pai bana khara am phange khara son bana khatang phange aduna National Legal Service Authority Act Legal Service Authority Act 1987 hai article 39 capital E da haiba objects ki matungi da lingkhat pare magi paundamji karino haiba tamda India da lebi khudimak logi sakthung phajana phangni aduga darkar aiba matamda legal aid supini haibne aduga log adalat kumba tobasina adu sum yauri aduradi kana se free legal aid phangba yagi haise sida yaw section 12 sida mathang jo habi rani adu wai just ai si topics yaw jai na khitang hiding tone nupi angang schedule caste schedule tribe industry ki worker koi victim oiraba koi haidi ising isaw na khangti khusem amasum bahusha gi oiba yani khudong thiba ma dagi victim oiraba adura ji ga si Manipur thoiba 2023 dagi si khusem gi mob ama thokna irang thokna leiba si victim sisu legal service ta free legal aid phangba yai aibu adu khatang haijine bune adu ga jail la leiba jail haiba na te custody leiba jeje ta leisu hospital la leisu mental retarded home da leisu any sumada leiba adu ga is the cell worker adu ga Manipur go da sahi da 53 lakhs phogi income gi bakha da bi se phage aduna IDP sing di nupa ogira nupi ogira angang ogira SC ogira ST ogira general ogira OBC ogira loida free legal aid phangba yai ha sing mutang ina hygiene gune te makha ta bari khoi technical session da hairani Pathagda Oja Premananda su haibi 3 criminal law. Sikamai lai do hana leme IPC CRPC evidence na leme. Adobo sahi samagi sadigi mamagi law ni na. Ano development yam lakpo se amendment sum tawraga su yarakta na recast of Ahongshangbam judicial precedent mayam amala zero FIR have se hana gi IPC de yaudi CRPC de yaudi ano BNSS ta hape ko ade adubai tongdra kana gumba na police ta satlaga complete FIR to bi de FIR to ya hadragadi haran kamai to gi se CRPC de yauru su exactly yaudi 156.3 na hana CRPC de yawe ado Kamain Thadun she talked about Priyanka Srivastava, State of EP, the Supreme Court of 2004, 5 Soida, Amaza 15 Soida judgment of 2000 Karosida. Police the affair to be on Saturova, Police Osina Togatrava, yes, with the Zoom report over Adu Tobaya Dragadi, Kota affair to Hunbu, Dragas Havia, si Priyanka Srivastava the Hava, Adu Hosik, si BNSS is the happy. Aduna masagi court laiba tariba batamatam gi judgment mayam direction mayam se sum I amend toroga hapa sum yadamina amend toroga di sum phi khom phot pa song khon oledo ama hainai dana phi khom lerega sum sagai bi phot pa sound mate phot last song khon oledo adu gi phiam lak torina ano bo lo ma saba darka lai haibri hana gi criminal law hum se si bahuta BNSS amasum BSA haibse Anobu lakpani adubu 90% di handagi yauri anoba judicial interpretation adagi suppose hoji electronic ki mayam se hanagi evidence sector ke ayauti aduna sumu je habakwa adagi akoi bathangi da electronic evidence haibam yauri adoga sigi aina khatang khudong chalo ga sigi sida police tak haim yaure aduna criminal law da mayam na ma haidna court sakradi heta adum thadok khrani haye courti pujari neba Jack Tomo Minebuko. Police na isang lay rudoini. PP na isang sima pisilatoini. Nga apumba sereng apumba layer poraga sereng apumba do kakpo kaktaboy pisilaga di pana hiba bamon ni agasu isang do manam nam tirani. Aduna criminal case success oibse. Conviction equitel habido di outcome ni document based ovani evidence based ovani. Adubo police ki sida am lay police na insang afaw khala laiba darkha ta investigation to buda semi pujari ju chang nai na kaktana khotna sana ka orga sukchong ka di mullaroi taw da ko nga su ko aduna si sange aduna pp gi mathau court asidiri bayam du pusila ka to laga thong molina aduna judge gi mathau sina pujari udoi ne ko aduna di police na investigation soiraba faulty investigation is 99% guarantee for acquittal. Police na fajana investigation to rosu PP na fajan to utragadi ha nga do leraga fabalera thamaga su PP na musada phawaga pumhan basu yaidna ko lera ko di police na fresh laser so aduna si mayam se coordinated ama sange ko aduna aina haizabdi aduna police ki role am sawi they are the primary collector of the evidence PP analysis tawraga amu court puthok toini judge na taraga decision pi toini judge di kano atane ba megi la pugum ne ba megi audited megi la ga isa yadre ko afaba la ga di ano fresh la ga di misaba yare na ko aduna packet su expiry obe yade na ko aduna sigi aina haje di PP gi role ga judge kano ga police gi role ga se criminal justice ta is very important everything depends upon their hard work judges have their own limitation Judges the material based on the material came out of the gatility, judge the person knowledge hapayate. Adu Katanga, as I said, court by outcome say, police cap PP, they have no Mahapole, Dukaki Hajavane. Judge the also out the heavenity, judge the Maishu Asumba Toroko cannot away. Aduga, Ajaki, Hajaki now a train of the Karosi electronically cyber the Laponina. Electronic evidence issue sang basi darka o having a chapter ba yawse sisu police ta darka yamna taba kanone alala ayam sangna ji haijaroi adubo hanagi evidence sector yawa 65B capital B secondary evidence of electronic Hojaki BSA dana 63. Saptimani BSA giti judgment like 3 aduna hana evidence ki 65 ki judgment anor an AV anwar dagi horaga. Hojik last laiba hoyi kari Pandit Rao ka anjur Pandit Rao marakta safiu di na khara stress athorure. Aduda phajana haire aduna police na su investigation collect tong matamda secondary electronic evidence hoiragadi certificate loba darka ta bisima khangbiyo certificate yaudagadi that evidence is not admissible during the trial aduna shikhar se hajaraga aina resource asset mayam gi waloi ngthokre is only introduction. They will give their own view, detailed view. I am just throwing what will the after lunch, what will be the sin. I see Krasi Hajaraga, I am Matang Saidal Sinjar.
Thank you, Honorable Justice A. Bineshwori Sharma, our guest of honor of today's program. Next, I would like to read out a small, brief introduction to our next guest of honor of today's function, Justice Bimol Singh. Justice Bimol was born on 1st of February 1966 in Kaisamthong, Ahantem Laikai. He holds a degree in BA and LLB. He was enrolled as an advocate on 20th January 1994, and he has over 25 years of extensive legal practice in service, constitutional, civil, revenue, and administrative law before the High Court of Manipur and the Supreme Court of India. He has an illustrious career of institutional service as well. He served as standing counsel and legal advisor to Jawaharlal Nehru Institute of Medical Sciences, JNIMS Porampat. He took oath as additional judge of the High Court of Manipur on the 18th of March 2020, and he was confirmed as a permanent judge in the March of 2022 by the Supreme Court Collegium. Justice Bimol has notable judicial contributions, impactful judgment. Mention can be made of retired benefits of employees, his key role in ensuring internet access for essential services during statewide internet shutdowns during the unrest period of Manipur, May of 2023. So it is with great pleasure that I welcome Justice Bimol as he stands for procedural fairness, timely justice, and constitutional integrity. I request Justice Ahantem Bimol, Justice High Court of Manipur, to come up and present his speech as guest of honor.
A very good morning to everyone present here. My esteemed brothers, Sri Kampya Somaseka, the Honorable Chief Justice, High Court of Manipur, my brother Aribam Guneshwar Sharma, Judge, High Court of Manipur, Sri Ojes Motum, Registrar General, High Court of Manipur, Dr. Y. Premchand Singh, the distinguished member of the Manipur University, Mr. N. Kritijan, District and Session Judge Bishnupur, and all the judicial officers present here, Sri Ravi Kumar, Superintendent of Police Bishnupur, and all the police officers present here today, Srimati Eliza Maisnam, the Principal Royal Academy of Law, and all the teaching faculties of this STEM college, Mr. Bimol Chandra, President Amba, learned members of the bar, all the members, ladies and gentlemen present here, and especially the students of law. It is a privilege to stand before you and share some of my thoughts in connection with today's program. Today's event has encouraged me to think that despite the difficult times in the state of Manipur, over the last 2 years, there is no dearth of people among us who are still determined to continue with good works. The participants present here today may symbolize our resolve to establish the rule of law. A legal awareness program organized within the premises of Law College is always a moment to remember. It was on the 1st of July last year that the 3 new criminal laws, which we now popularly refer to as BNS, BNSS and BSA, came into effect. The Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, and the Indian Evidence Act of 1872 have been the foundational pillars of our criminal justice system. Their replacement, therefore, naturally excited debates and discussions. Certain reasons and objectives were behind the enactment of these new laws. The lawmakers felt the need to get rid of the baggage of colonial era which no longer served any purpose, and to do away with the outdated language and concepts. The transforming power of technology also necessitated changes in and innovation in law also. Some key changes have been brought by these laws either by introducing altogether new ideas or by giving prominence to emerging concepts. One of them, which appeals to me, is the victim centricity that takes center stage in BNS and BNSS. For instance, Section 173, subsection 2 of BNSS requires that a copy of the FIR be furnished free of cost to the victim. It may interest you to note that Section 193, subsection 3, clause 2 provides that the police officer shall, within a period of 90 days, inform the progress of the investigation by any means, including through electronic communication to the informant or the victim. The concept of zero FIR has now been given statutory mandate in view of Section 173, subsection 1. There are also provisions for recording information relating to commission of certain offences against women and disabled persons, which are specifically designed for their benefit and convenience. We can notice some modernizing definition and tackling new crimes. The controversial Section 124 capital A IPC, which provides punishment for sedition, has been replaced by Section 152 BNS, which focus on acts endangering sovereignty, unity, and integrity. Section 103, subsection 2 BNS, which provides punishment for murder when committed by a group of 5 or more persons acting in concert on the ground, may address the critical social issues of mob lynching. Terrorism has been defined and a whole chapter has been dedicated to the subject. Provision for organized crime has been added in order to target organized crime syndicates. With regard to sexual offenses, gender-neutral provisions have been expanded, gang rape of minors included, and there are provisions dealing with voyeurism and imposition of stricter penalties for rape of girls under the age of 18. Section 69 BNS concerns with deceptive relationships. It provides punishment for sexual intercourse under false promise of marriage, employment, etc. The new laws provides remedial measures to curb procedural delays It has provisions to ensure faster investigation, such as mandatory forensic team visit for crimes punishable with imprisonment with 7 years or more, use of technology for evidence collection, electronic summons, serving summons, bills, SMS, emails, etc. Mandatory videography is required for search and seizure and for recording statements of rape victims, thereby enhancing transparency and reducing manipulation. Timelines have been prescribed for procedures like filing charge sheets, medical reports in rape cases, bail orders, and judgments. The new laws are also designed to tackle the explosion of cybercrime and handle digital evidence. Electronic evidence is equally valid as physical records. Emails, server logs, messages, digital documents, and even location data are explicitly recognized as primary evidences. There are provisions enabling electronic trials, such as provisions for conducting trials, appeals, and recording of deposition electronically, enabling accessibility and efficiency. These changes brought in by them is intended to create a justice system that is Indian in spirit, modern in outlook, victim-centric, and aligned with 21st century realities. Like all things newly introduced, their implementations, however, have come with certain challenges and difficulties. First, there is a need for proper infrastructure to carry their mandate in letter and spirit, especially in recording, assessing, and preserving the electronic evidences. Second, I may say, is the need for continuing the training for police, prosecutors, and judges. The third is the interpretation of the new laws, which is an area of interest to both the academic circle and law practitioners. I have been told that when BNSS first came into force, there was uncertainty even on the basic question as to under which law bail applications should be filed in the FIR if the FIR was registered prior to 1st of July 2024. Adding to that uncertainty was different views expressed by some high courts in the early period. The Punjab and Haryana High Court, the Kerala High Court, and Delhi High Court took the view that BNSS would apply in such cases. However, the Rajasthan High Court in Krishnan Joshi versus State of Rajasthan expressed a different view. We are gradually moving towards resolving all issues. We are beginning to see attempts by Honorable Supreme Court and High Courts to take care of grey areas and give interpretations to remove ambiguity. The Supreme Court, in inhumane condition in 1382 Prisons versus Director General of Prisons and Correctional Services and others, delivered a significant ruling on 23rd of August 2024. It held that Section 479 of the BNSS would have retrospective application to other trials across the country. This provision, which replaced Section 436 capital A of CRPC, allows for the release of other trials on bail under certain conditions. First-time offenders have to be released on bond if they have undergone detention for a period extending up to 1/3 of the maximum imprisonment period specified for alleged offences. A bench comprising Honorable Justice Abe S. Oka and Honorable Justice Ujjal Bhuyan ruled that under the proviso to Section 223 subsection 1 of the BNSS, a magistrate or special judge must hear the accused before taking cognizance of offences under Section 44 subsection 1 clause B of the Prevention of Money Laundering Act 2002. Meanwhile, the Chhattisgarh High Court in Parisa Trivedi and another versus State of Chhattisgarh expanded judicial discretion in anticipatory bail under Section 482 BNSS by noting that the removal of guiding factors from the CRPC allows court greater flexibility. This shift has sparked debate over potential inconsistencies in bail rulings. Certain issues are also agitated before the High Judiciary in recent times. A public interest litigation before the Kerala High Court is challenging Section 69 BNS, which criminalizes sexual intercourse based on false promise of marriage, arguing it is regressive and discriminatory towards LGBTQ community. Similarly, a petition filed by former MP Vinod Kumar Boinapale in the Supreme Court questioned the constitutionality of provisions like Section 113 BNS on organized crime and terrorism and Section 173 subsection 3 BNSS allowing preliminary inquiries before FIR registration. In conclusion, I dare say that what matters most is execution of ideas. No matter how lofty the noble the thoughts are, they remain important unless acted upon. The success or failure of our criminal justice system will, to a large extent, depends on how determined we are to implement the new 3 laws. No doubt, their inherent strength will aid us in this endeavor, but even the perfect law needs to live through the words and deeds of man. The first requisite for implementation of law is, however, their proper understanding. This awareness program on arrest and detention under criminal law, BNSS, PSA, and its impact on serious offenses and electronic evidentiary issues is a step towards that direction. I should congratulate all of you for your keenness to learn and share your thoughts. Above all, I should express my profound satisfaction in seeing young students present today who are grooming to become enlightened citizens. Jai Hind.
Thank you, Honorable Justice Hantem Bimol Singh, Justice High Court of Manipur. Now the most awaited part of the program, guest speech by the chief guest. But before that, it is my honor and privilege to introduce and say a brief introduction to our distinguished chief guest of today's program, Honorable Justice Kempaiah Somasekhar, the esteemed Chief Justice of the High Court of Manipur. Honorable Justice was born on the 15th of September 1963. He began as an advocate on 27th of January 1990, practicing in both civil and criminal laws in Mysore and Chamarajanagar. He became a district and session judge on 17th of June 1998, serving across Karnataka in regions like Bijapur, Bangalore City, Civil Court, Uttar Kannada, Hassan, Chitradurga, and Bangalore Rural. He has held administrative leadership as well. He has held important posts as Registrar Judicial, Registrar Vigilance in High Court of Karnataka. He was elevated as Judge of the Karnataka High Court in November 2016, and he became a permanent judge in 2018. He has served with distinction for nearly 9 years in the High Court of Karnataka. He then assumed office and was appointed as the 9th Chief Justice of Manipur of High Court, and he took oath on the 22nd May of 2025. We have notable judgment, we had seen from him during his tenure on the Karnataka High Court bench between 2016 and 2025. Justice Somasekhar is credited with multiple influential rulings that demonstrate his commitment to balance justice and adherence to constitutional values. He has delivered landmark rulings upholding victim rights, procedural fairness, and constitutional morality. Strong proponent of timely justice, and has ruled against misuse of procedural law. In criminal law, he emphasized the importance of motive analysis and the charge requiring, discourage requiring multiple witnesses when circumstances demand simpler proofs. Sir, I had the opportunity to watch your farewell speech, which was available on YouTube, and I could draw some philosophy, pardon me if I was wrong. He believes that the Constitution is not merely a legal text, but a moral compass, is what he says. Advocates equal justice, accessibility, and judicial independence. He is a firm believer in human dignity and, most importantly, the rule of law. Ladies and gentlemen, may I present before you the chief guest of today's program, Justice Kempaiah Somashekhar, the Chief Justice of High Court of Manipur. May I request you to say a few words in relate to today's program, sir.
Good morning to each one of you. My dear brother, Justice Bimal Singh ji, and also another my dear brother, Justice Sharma ji, and the dynamic Registrar General, High Court of Manipur, Mr. Hojis Muttam, and on the dais, the professor in the concerned department. Of the dais, the district and session judge, Bishnupur, and also the CJM, who is a member secretary to the District Legal Services Authority. As I have noticed, of the dais, 2 judicial officers in the rank of the JMFCs, and inclusive of the head of the law enforcement agency as a superintendent of police, and police officials and officers, and also resourceful persons, inclusive of advocates and other audience. My dear, 2 brothers have been addressed the issues relating to the subject on this day in this unique legal awareness program, inclusive of that professor of law. But as a Chief Justice of this state of Manipur, addressing an issues relating to the scope of Indian Penal Code, Criminal Procedure Code, inclusive of Indian Evidence Act. Now it is amended and also come into force on 1st of July 2023. But dwelling in detail about each one of the provision of law in this country, it is not so easy. But media persons are here. They must be very consciously to dispel the information from the dais to the public in general, and also to the audience. Because state of Manipur, I don't want to say that it is very sensitive, but the district and session judge should be very sensitive judge, and inclusive of the judicial magistrate of the first class as well as the CJM. But so many subjects are there, as I have noticed on these days some scheduled program. But each one of the subjects are concerned, we must be very consciously to say that, keeping in view the time sense, because the time sense is most important, rather than rendering any subject, because of timely justice, inexpensive justice, and speedy justice. These 3 components are most components, as keeping in view Article 21 of the Constitution of India, and equally Article 14 of the Constitution of India, and more importantly, Article 39A of the Constitution of India. But Article 39A of the Constitution of India relating to way back, the Legal Aid Board in the year 1987. But subsequently, the Legal Aid Board, it was to otherwise to say that as a legal services authority. It is to be said that NALSA, National Legal Services Authority, then we call it as a STALSA, otherwise SALSA, State Legal Services Authority, then District Legal Services Authority, inclusive of the Taluka Legal Service Committee. But there shall be an important role to each one of the committees and each one of the authorities. But the professor was referring some of the judgments during his speech to the audience. I am very consciously to say that one judgment it was rendered in the Karnataka, that is Shraddhananda Swamiji. Shraddhananda Swamiji was committing an offense of 302. I am very consciously to say that because of the medias, sometimes disclosed in the newspaper, even though it is under the Right to Information Act of 2005, but it is not so easy. Because in this audience, the law enforcement agencies are there, inclusive of my judicial officers, and so also the advocates, and inclusive of the budding advocates. In future, they will be the property to this great institution, also this great country. Because of the reason, as a professor of law, it is very easy for rendering a speech. But as a sitting judge, in any rank, inclusive as a Chief Justice, in one word has to be spelled out. It is amount to an order. Once it is an amount to an order, it ought to have been executability. Otherwise, the society will be taken into some views relating to that. In the so-and-so scheduled program, this kind of speech was done, it will be the good ground for them to agitate. Because of the reason, very consciously to say that, what is Indian Penal Code 1860? In the year 1860, this Indian Penal Code was enacted by that Lord Macaulay. Lord Macaulay was the author of the Indian Penal Code 1860, and this IPC was consisting in all several chapters, and more importantly section 1 to section 511 of IPC. But now it is extended, some of the provisions here and there shall be some corresponding provisions. For example, 302 of IPC, it is a murder. Now it is, according to my memory, whether it is switched over to 100 or 101 and some things. Then 302 of IPC, it is known to the everybody since 1860 onwards. What is murder? In 302 of IPC, it is a definition. We have to be looking into the two areas in that Latin terms. What is mens rea and what is actus rea? The professor of law and also the law students, including the lawyers and including the law enforcement agents in any rank, they should be understand first what is mens rea and what is actus rea. Then only we can able to understand what is the real intendment of a felonies or a perpetrator or an accused to committing an offense. But section 2 of the Criminal Procedure Code, it is defined therein. Almost all entire Criminal Procedure Code, it consisting in all section 1 to section 484. Everything it is defined in the definition section of section 2, A, B, C, D up to Z. Very consciously to see that what is complaint, what is bailable offense, what is non-bailable offense, what is warrant, what is non-bailable warrant, then what is summons, what is cognizance. Therefore, it is very difficult. It is very difficult to concentration of a particular subject, either in the Indian Penal Code 1860 or otherwise the amended, what we call Bharatiya Nagarika Adhiniyama and Bharatiya Nagarika Sakshi Adhiniyama, Bharatiya Sakshi Adhiniyama. But everything it is only substituting words. But here and there it is disturbed. Somewhere 1860, that is IPC, the Criminal Procedure Code was come into force in the 1861 originally. But how long? In a very, very long duration. We have to be memorizing each and every provision of law. Presently these three enactments were said to be amended and also give to us. It will take another decade and decades to memorize each one of the provision of law in IPC, CRPC and Indian Evidence Act. But Indian Evidence Act was come into force in the 1872. Who was the author of that? Lord Stephenson. Lord Stephenson was the author of the Indian Evidence Act 1872. This Indian Evidence Act was consisting in all section 1 to section 167. Now it is extending certain provisions here and there. There shall be some corresponding provisions. But corresponding provisions in the Indian Evidence Act, Indian Penal Code, even to the extent of Criminal Procedure Code, the definition is one and the same. The understanding is one and the same. The ingredients are one and the same. But we, the human beings, must be dwelling in detail to apply our mind. As a law enforcement agency, who are the investigating agency, we call it as an investigating officers. They are the officers initially visit to the scene of crime, we call it as in our side. Scene of crimes means the spot as where the incident was occurred. And securing the punch witnesses who are the elderly person in that localities, in that vicinity. There is no restriction in the CRPC. Then who was a person is acquainted, then only to drive the spot mahaja. And also further, in case the dead body, it was lying on the scene of crime, otherwise lifting or shifting from there to the any autopsy center in the medical department. Then the inquest for the dead body has to be held. It is only by the investigating agency in the rank of the, neither may be head constable, or maybe a ASI, or maybe a PI, otherwise may be the DYSP, and sometimes in case it is a sensitive case, a superintendent of police. The inquest held over the dead body, there shall be some column. That column has been specifically stated in the Criminal Procedure Code itself. In case in a 304B of IPC, now it is a different corresponding provision. That 304B of IPC, it is a dowry death. Normally dowry death, it is a corresponding to the another provision of section 498A of IPC. In 498A of IPC, it is amount to outraging the modesty of a woman, sometimes 354 ABCD. Now it is amending provisions. But 498A specifically, there is a definition that is physical as well as mental harassment. It is very difficult to define what is physical harassment, what is mental harassment. Otherwise to say I am using mental injury. Mental injury, it is very difficult to define it. Even mental harassment is also very difficult to define it. I am asking that professor who is on the dais to answering to me, what is an injury, what is an harassment, what is mental injury, what is physical injury. Physical injury, it can be noticed. It is only for slapping. It can be slapping on any of the parts of the body. But mental injury, it is always causing some harassment and injury in the brain. It is very difficult to define it. But these brains are consisting, according to the medical ethics, 86 crores of neurons. 86 crores of neurons of this brain, it consisting. It is very difficult to define it. Because of the reasons, it is a software, brain is a software, skull is a hardware. But a creator, very cleverly, very intelligently, putting this software brain into the hardware inside, hardware. Otherwise, it is very difficult. It would be also causing damages. Because of the reasons, today's scheduled program, my dear brother, who is a Legal Services Authority, as a chairperson in the state of Manipur, and another Sarmaji is also chairman in the High Court Legal Services Committee. These are all the subjects in case dealt and also rendering to the audience, consisting so many stakeholders. It is not so easy for delivering that speech towards each subject. Because of the reasons, in the opening I am using that word time sense. The time sense, it is most important. But the time is at, brother, 12:45. But I want to say that our judicial officers are present. What is cognizance? It is very difficult to define what is cognizance. It is in section 191A, B and C. What is 191A? What is 191B? What is 191C? What is section 200 of CRPC? What is private complaint? What is a complaint? It has to be received by the police officer to immediately switch over to recording an FIR. What is an FIR? What is an investigation report? What is the scope of section 167 of CRPC? What is the scope of section 173 of CRPC? 173 CRPC, filing a charge sheet. What is a charge sheet? But 167, Roman number 2, clause 3, so on and so forth. Charge sheet is thought to have been filing by the investigating agency. It is depending upon the offences alleged in the FIR, either in 60 days or in 90 days. In case special enactments, it may be 90 days plus another 90 days, extending that power. 60 days, 90 days, 90 days plus 90 days in a special cases. Such kind of intelligence, it is very much required. Otherwise, difficult to address the issues in a bail petitions filed. 436 CRPC, no problem. It is a bailable offence. 437, there shall be some problems. It is a non-bailable offence. 439, it is a greater extent. It is before the district and session judge and also before the High Court. But 436A of CRPC, now it is a corresponding provision is there. In case the accused is in judicial custody, 1/4 of the main offences, that accused, he had to have been released by imposition of certain conditions. That is the objectivity of what is 436A of CRPC. Section 357 of CRPC. Now it is amended 357A of CRPC. What is victim's compensation? The victim's compensation, it is a mandatory. That mandatory power it ought to have been exercised by the judicial officers in any rank. The cognizance, it is not so easy application of mind. Whether application of mind, whether mental equipment or mental action, it is very easy for us. I am asking the professor of law. The cognizance, it is not so easy to be taken immediately. The cognizance, it is to be taken only to looking into the materials available on record. But another thing is here in arrest and detention, that is the main concept. What is arrest? What is detention? Arrest, that power is vested with the enforcement agency. But the detaining the accused, it is also the power, it is vested with the magisterial powers of the district, magistrate in the districts. As a district collector, as an executive magistrate second class, that is a taluka, tahsildar. Their power is only for 7 days be extending and remanding the accused. But the judicial magistrate, the first class in any court of law in this country, having a power that remanding the accused not less than 15 days, exclusive of these days or that days. That is the power, it is vested with the judicial magistrate of the first class, including the CJM and district and session judge. But section 193 of CRPC is there. The district and session judge, special district and session judge sometimes be taken cognizance. In SCST Act, any charge sheet has been laid. In case of Order Act, any charge sheet has been filed. Even Copy Force Act, but here is no. But here is only National Securities and National Investigating Agencies Act. But I have noticed in section 21 class 5 of the National Investigating Agency Act. But there is a chapter appeal. What is appeal? What is judgment? What is a sentence? What is order? Every wordings, every phrases, it has to be looked into as it is in our insight. Therefore, not so easy for defining each and every aspects in respect to the court of law. The judgment writing, it is very easy. It is only hearing the arguments on both the sides. But investigation to be carried, that the difficulties, it is known to that investigating agency only. Subsequently, it is known to the difficulties of the judicial officers. But today is a scheduled program only for legal awareness. Awareness to the general masses. Awareness to the marginal section in society. My brother Sharmaji expressed the wordings as scheduled castes and scheduled tribe and OBC. It has specifically stated by the constitutional makers in Article 340, 341 and 342 respectively. Then some harassment at the workplace, Vishaka versus state of Rajasthan. Then legal aids with legal services. And what is the arrest? What are the requisite conditions are required to be followed by the D.K. Basu's case is there. And time and again the Honorable Supreme Court has been rendering so many judgments, highlighting so many provisions. But referring the Article 226 and 227, the professor referred. What is Article 226? What is Article 32? What is Article 227? Yes, Article 227, it is a supervisory powers vested with the High Court. But Article 226 relating to the writs for all 5 writs. But in Article 32 of the Constitution of India, there shall be also dealting the writs power. It is directly to the Supreme Court of India, honorably. if there is any violation of the fundamental rights. But Article 226, even though we have to be dealt, but in the arrest and detention are concerned, Article 22, Clause 5 and some things, whether it is the arrest is in accordance with law, the detention is in accordance with law, the detaining order passed by the competent authority who is a district magistrate is in accordance with law. It has to be tested, it has to be scrutinized by the state's higher judiciary as a high court judges. It is in the habeas corpus in nature. Because of the reasons, delivering a speech, it is not so easy of all these three enactments. This country consisting 140 crores of people, we have to protect the rights of each one of the citizen in this country, not only to this area. Because of the reasons, very consciously to say, what is CRPC, what is IPC, what is Indian Evidence Act. But ultimately, whatever the evidence, whatever the exhibited documents, whatever the case was putting forth by the prosecutors or the defense counsel, but the role of a prosecutors and role of a defense counsel and role of a judge. But Section 3 and Section 4 of the earlier Indian Evidence Act, it is defined as proved, disproved and not proved. Proved, it is not so easy. Disproved, it is also not so easy. Not proved, it is also not so easy. But appreciation, it is vested with the presiding officer who is sit upon the subject matters. Because life and death in the hands of the judiciary. We are always dealing the fundamental rights, constitutional rights, statutory rights, and natural rights, and ultimately human rights. That is most important rights, human rights. Even the awarding death penalty by a session judge, by a trial judge, awarding death penalty to the extent of an offense in which he has committed, but his body is disposed of by hang him to death, but his soul is an eternal. The soul is an eternal because of the reason consciously Section 499 and 500 of IPC has been enacted by the Lord Macaulay. The soul is always lingering some justice. Because of the reasons we must be rendering justice, it is firstly to the body, nextly to the soul. The soul is an eternal. Because of the reasons the judge post the investigating agency's powers and function and the role of an advocate, it is not so easy to define it. The advocates must be very consciously to conduct the case on behalf of the accused, and the prosecutor is also very consciously to conduct the case on behalf of the prosecution bureau. Acquittal and conviction, it is a beyond reasonable doubt and benefit of doubt. Benefit of doubt, it is ended, the case would be ended in acquittal. Reasonable doubt, it is only beyond reasonable doubt, it is only for conviction. In conviction also after where it is not so easy. Section 360 of CRPC is there. Section 3, 4 and 5 of the Probation and Offenders Act of 1958. Whether the convicted accused is a first timely committing an offense, what is his family's background? What is his antecedents? These are all the things it should be looked into by the sentencing judge, by rendering a conviction judgment. Even after rendering a conviction judgment, he can't be washed his hands with any detergent. it should be looked into section 360 of CRPC akin to that PO Act. These are all the areas are very much required to be addressed. And therefore, due to some paucity of time, this scheduled program, it has been scheduled by my dear brother Bimal Singh ji and also my dear brother Sharma ji, giving an opportunity for me to rendering this kind of message to you all in these podiums. But one thing I would like to say that in the last, not but least, wish you all the best to the investigating agency, to the defense agency, and also prosecuting agency, and more importantly, my judicial agency consisting the JMFC and also the CJM and the district concession judge. Again and again, I will be remembering, life is very precious. Because of the reason, Article 21, liberty and life is there. Liberty and life, it is go hand in hand. Imposition of the conditions by granting a bail, it is only mere because granting, but imposition of the hefty condition, then it is nothing but as a deprive. Very consciously to exercise the powers by each one of the judicial officers in the rank till the district and session judges. And to that extent, this message as I would divulge to you all in these unique functions. Wish you all the best. These programs would be a success. It is in the interest of justice, and justice shall be rendering to the society. And it seems to have been done. Thank you so much.
Thank you, Honorable Justice. Honorable Justice Kempaiah Somashekhar, Chief Justice, High Court of Manipur, to have shared his views and foresight. We hope to see a justice system that strengthens the rule of law and ensure fairness for all and contribute to the lasting harmony and peace for the state of Manipur. Taking this opportunity, I would also like to say a few words regarding this college where we are hosting today's program. Our college was established in the year of 1994. It has been 31 years of academic excellence wherein this college has been imparting legal education to the state of Manipur. We are the only college under the Manipur University, and we are the only NAG accredited college with a rating of B grade. And we had got this accreditation in the year 2024, the preceding year. We also have our own dedicated mediation center, which was established on 15th of February 2023 by the then, and it was inaugurated by the then acting Chief Justice of High Court of Manipur, Sri M.B. Muralidharan. And we also boast of having our own pro bono club, one of its kind, the first pro bono club in any college or in any institution. We have that one in Royal Academy of Law Oinam, which is still functional and which is imparting pro bono work in the state of Manipur. So I would like to extend my thanks to all the teaching and non-teaching member staff of this college. Also, the founder, father of this college is with us here, Sri Singh. It is his sheer dedication that this college still stands tall and imparting legal education in the state of Manipur. Our college is not a full-fledged government college, an aided college, but still, even facing the financial crux, the teaching, non-teaching staff, and the whole administration of college is able to impart quality legal education to the state of Manipur. And how to describe our Madam Srimati Bineshwori Maibam is a shining example of a product of this college. She is a product of this college, and it shows the sheer dedication of all our teaching and non-teaching staff in imparting excellence, legal excellence education in the field of legal education. Thank you. We will now proceed to the last phase of the first session, which is a felicitation program for our police personnel. Why we are hosting that, I would like to say a few words with regard to it. We have a list of police personnel, and we would like to felicitate them. This was this was because of the District Legal Service Authority, Bishnupur. They take the opportunity to recognize, to honor Sri Khetri Mayum Ravi Kumar Singh, IPS Superintendent of Police, Bishnupur District, for his outstanding support and coordination during the recent visit of the Honorable Judges of the Supreme Court of India on the 22nd of March 2025. His exemplary leadership, meticulous planning, and unwavering dedication ensured that every aspect of the visit, from security to logistics, was headed with the utmost professionalism and care. So we would like to felicitate Sri Khetri Mayum Ravi Kumar, who is the Superintendent of Police, Bishnupur District, on this occasion. Along with him, we have a list of police personnel with whom we want also to be felicitated. So if you are ready, we would, first of all, I would like to call upon Sri KSH Ravi Kumar, IPS, Superintendent of Police, Bishnupur, to come up the stage. He would be felicitated by our chief guest of today's function, Chief Justice Kempaya Somasekhar. Let us give a big round of applause. Sri KSS Ravi Kumar IPS has been presented with a lengyan and a memento of thanks for his dedicated service during the visit of judges in the a few months ago. We have now some list of police personnel which we would like to felicitate. Few personnel are absent due to various reasons, but we still would like to mention their names. Wangkomba Okramcha, MPS, Deputy Commandant, 2nd IRB, attached as Additional SP Bishnupur. He is not present with us today, but I would like to mention his name. Next, I would like to call upon Sri Amarjit Singh Lamabam, MPS, Additional SP Operations, to come up the stage. He would be felicitated by our Justice Bimol Singh. Sri Amarjit Singh Lamabam, MPS, has been presented with the lengyan by our Honorable Justice A. Bimol. Thank you. Next, I would like to have this opportunity to request Yumnam Premjit, MPS, Additional SP, Law and Order, Bishnupur District. And he would be felicitated by none other than our Honorable Justice A. Guneshwar Sharma. Thank you. After this, I would like to request Laishram Khogen Singh, MPS, SDPO, Bishnupur. He will be felicitated by our guest of honor of today's function, Sri Ojas Mutum, Registrar General, High Court of Manipur. Next, I would like to call upon Sri K. Santosh Singh, MPS, SDPO, Moirang. He would be felicitated by Sri Dr. Yumnam Premananda Singh, Head and Associate Professor, Department of Law, Manipur University. Sri K. Santosh Singh has been presented by Lengyan. We have two other names who unfortunately could not be present over here due to various reasons, but still we would like to mention their names. Sri D. Robinson, MPS, DSP CDO2, and P. Sanjoy Singh, MPS, DSP CDO1. They are not here at today's program due to various reasons. So with that, we have come to the end of the first session of today's program. We will now break for lunch. We will be again present to the seminar hall back at 1:30 p.m. after lunch, where we will have technical session 1 and technical session 2. So with that, we break for lunch. Hello, aduga kangan jabamana. Ako yung lunch spec, ako yung loina audience yung loina lunch spec asi ako yung sinjari. Aduna audience mayam, kasi dalag pero invitees mayam so ako yung seminar hall sida. Langsin birak tu ako yung lunch spec asi lawin na ba ning sinjari. Ako yung lunch sabam ako yung ani thong na sinjabani. Seminar hall por hendro na. Aduga ako audience ngasi gi lakive invitees mayam loina bag ako gi seminar hall da sangsen birak na ba ningsing jari lunch pack asi ako na sida pizza na bagi damak da kangan jari. Ko imai ben lekai sigja program su yobi rak ba lakpi ba khayam sida lakpi na ba ningsing jari seminar hall rom da. Ako na mayam gi damak ta chaklin lunch pack sinjari. Ada seminar hall is the lengthen birak tu na lunch pack asi ako na lobi na bagi damak ta ako na kangan jari ako na lunch apa masih ani thok na sinja bani amuka suhana ningsing jage ngasi ki audience o gi big hiwa khwai pum na makpu aina amuka suhana seminar hall om the lengsin birak na bigidam ningsing jari seminar hall asida akoina ngasi gi sinjari ba lunch pack asi lobi na bagidamakta hanna amuka suhana khangan jari ngasi gi program asibu midiang tabi ba lakpi khibi khwai pum na mak audience pum na mak seminar hall rom the lengsin birak na bagidamak ningsing jari ako na sinjari ba lunch pack asi seminar hall rom da lobby na bagi damakta ay namuka suhan na ning sinjari
Nah, bro, skin dia. Mana deh? Mana memang mana deh?
CJ 같은 당질할게 madam. Simay pangri. Adu moide par am taam ko. Simay je kan to bibine thaina. Hangasa. Tati ngasa ti thaina diam to bole. Ya madam. Sidi ka pammo ba. Oh, hamdi ni pendel. Zoom is the my skill no in the software ever. Should I get my other panel discussion the case you see your right resource Yani da. Mai PPT mi orang ko. Pasti PPT ki program orang dana praktani ko mo. Mana PPT program orang dana ko mai je. Oh ya. Oh. Inaugural session loi kharmatung aduga khoi lunch break lauro matung asida khoi technical session number 1 haunabagi damakta khoi sem sabal sinjare aduna khwai khibikpu amukasu hanna seminar hall rom da lengsen birak da bagi damakten singjari khoi lunch break lauro matung da technical session number 1 akhoi haunabagi damakta sem sabal sinjare aduna khwai mayam lakpiriba khwai mayam seminar hall rom da lengsen birak na bagi damakta amukasu hanna singjari ngasi technical session asi session ani thok na khoi khaidok jabani technical session 1 and technical session 2 aduga panel discussion amaga aduna maru oiba nunggi oiba program gi maru oiba session singdi evening afternoon session asini aduna masi gi session asibu mayam khoi khibikna mideng tabi na bagi damakta aina mukasu hana singjari technical session hauna bagi damakta sem sabal sinjare khoi khibik lunch break laur matung da seminar hall rom da lengsen birak na bagi dong ten singjari amuka sahana nisingzage akhoi lunch break lauraba matungda technical session asi haunabagi damakta akhoi sem sabal sinjarabanina technical session asi haujannabagi damakta ina mayamda amuka su khanganjari ngasi gi program asigi nungi oiba program di akhoi technical session asi oigadori bane aduga technicalities aduga akhoi gi details mayam di akhoi laiba resource person mayam asina khwai khibikta ngasi akhoi na tawjariba awareness program asigi akupa moral sing adu mayang from the khangan gadori bani ngasi gi program arrest and detention under criminal laws BNS BNSS and BSA 2023 haibani aduga akhoi na ngasi low reviews no impact akhoi organize serious offense aduga electronic evidentiary issues haiba akhoi hanagi ngasai akhoi distinguished guest mayamna haibikhiba hanagi law sing sida akhoi evidence akhoi electronic evidence kumbagi akhoi hiram asi yamna fazana yaugdaba asi handaki anoba law BNS BNSS amasung BSA da khara macha khaina yaurokpa adu akhoi mayamna khangminabagi damak ki akhoi tanja aduni khna lawjariba asi hojiki matam asidi akhoi digital world ni social media digital world akhoi thanaba yadraba virtual world amda leirabanina adugum lava evidence electronic evidence asi akhoi na yamna marumak oirakpa aduga masigi provision asi anobas akhoi law BNS BNSS amasung BSA da hapaktaba yaraktaba aduna akhoi changing crime hajiki anoba sophisticated oiba crime daidi magi motive mayam se hanagi akhoi na same kiba law adudi sahi cha kaya 100 koi gi British era gi colonial rule da hanagi seng rule oibanina anoba makhal gi crime mayama koi gi serious oiba offense mayama koi cover toba ngamna bagi damakta koi na anoba rule ahum criminal law ahum same kiba si koi na khana nei na bagi tanja aduni koi na lawjari basi aduna maru oiba nungi oiba akuppa marol technical session asida loina ba cover toga dori bani aduna technical session asi hauna bagi damakta aina mayang infam dasu amuka hanan nisingjari technical session ani leijai session 1 session 2 masida macha khaina akoina ngasai nena jakiba BNS BNSS masung BSA 2023 asi kupna neinaraga arrest detention aduga akoigi serious offense aduga electronic evidence haiba anauba hana sulai adubu yamna macha khaina hanagi ariba law sing sudadri yamna macha khaina yaugdaba adu handaki law sida yauslapani masi naina bagadam aduga koina technical session 1 and 2 sing sigi details si mayang from the thamjage ahan ba technical session da akoina thamjari ba si akoigi speech by TH Johnson Singh mahagasi DLSA gi retainer lawyer front office oibi Bishnupur gi mahagna ngasi gi program asigi mari leinana mahagna speech sama thamigani topic na the impact of legal services and its effect to a citizen under the Legal Service Authority Act 1987 haiba topic asida Sri TH Johnson retainer lawyer front office District Legal Service Authority Bishnupur na thambigani ani suba technical session da hoigi resource person obiri bi Nirasinam judicial magistrate first class kakching adu mahana thambigi the topic asina procedural irregularities in arrest or detention and its impact on remand and trial haiba topic asida koi ngasigi ani suba resource person Nirasinam mahakna thambigani hariba speech asi loilaga koi technical session ahum suba maga thamjari masidana muk akoi resource person Rajasri Yambem judicial magistrate first class Bishnupur aduga topic na electronic evidence on seizure and its admissibility under DSA 2023 haiba topic asida akoi resource person Madam Rajasri Yambem na miyang ifuna thambigani aduga hariba resource person sing asiki speech asi aduga session asi loyer matung da koina akoi apik pati break ama lauraga yam akoi panel discussion ama thamjari new criminal laws under BNS BNSS and BSA haiba topic asida adaga masida laigadriba panel member sing amukka hannai myang funa thamjage ahanba panel member Yalam Ramananda, Chief Legal Aid Defense Counsel, Bishnupur. Anisuba panel member, Sri Yumnam Premjit, MPS, Additional SP, Bishnupur. Ahum Suba panelists, Thoksom Hemchandra Mitay, Secretary, Bishnupur Bar. Media person, Thoksom Jogendrajit, IIS, Assistant Director, News, Akashvani Imphal. Aduga mga suba panelists oibigidaba Dr. Yumnam Premananda Singh, Head and Associate Professor, Department of Law, Manipur University, Canchipur. Aduga ngasigi panel discussion asigi moderator oibigidaba na Sri T.S. Sudhir, Deputy Legal Aid Defense Counsel, Bishnupur. Asigum laba kogi technical session 1 amasung ani suba koina khaidok charaga lunch break ki matung da thamjari. Ngasigi program gi maru oiba nungi oiba wafam amasung hogi akupa marol sing asidi hairiba technical session sing sida oina koina cover to jaga daboni adana aina mayam gusong ko hana ningsing jage hogi technical session asi koi hauna bugi damakta sem sabalo sinjare. Ngasigi chief guest amasung guest of honor oibikiba Singh giming amuka so ay namka kangan jage mayang mamangda hajikpadi isagi thabak na muk hankre adubu amuka so ningsing jage makoy giming koy ngasigi chief guest obiramba koy High Court of Manipur gi Chief Justice Honorable Justice Kempaiah Somasekhar koy Honorable Chief Justice High Court